Following the latest dismissal of the application for a judgment review by the ruling APC and its candidate to the Supreme Court, asking it to reverse its judgment on the Bayelsa state election, also the review application by the opposition PDP and its candidates on the Imo state election, and the threat by the PDP to seek a review of the 2019 presidential election, a renowned legal practitioner, Kayode Ajulo, has described the actions as worrisome and disappointing, to say the least. It is disappointing in the sense that the parties involved are represented by eminent members of the bar who are then familiar with the principle of law guiding appellate jurisdiction of the Supreme Court. It is worrisome in the sense that the grant of this strange indulgence may open a window of uncertainty and in fact in corruption of the age-long legacy of the Supreme Court is enshrined in the doctrine of finality of the judgment of the court and the desirability of putting an end to litigation. The opposition PDP had accused the ruling APC of putting pressure on the judges of the Supreme Court to reverse their rulings on the Zamfara and Bayelsa elections and warned that if the APC challenges the result, it would seek a review of the 2019 presidential election won by President Muhammadu Buhari. Former Associate Justice of the Supreme Court of the United States, Robert H. Jackson, in describing the finality of the Apex Court once said, "We are not final because we are infallible. We are infallible because we are final." Similarly, in the celebrated case of Adegoke Motors vs. Adesanya, Justice Oputa said the justice system may be susceptible to minor imperfection in some material particular, there must still be an end to litigation. It is in light of this that Ajulo believes that the moves by both parties towards the Apex Court judgment is an attempt to rewrite the law, count the Supreme Court to the ill-conceived public opinion sentiment which is currently being branded out in both the print and social media by some persons, and an attempt to ridicule the Nigerian justice system. Ajulo insists that the applications for review were an attempt by counsel to resubmit issues that have been or ought to have been submitted to the court for determination but were not, which he adds goes against the stipulations of Order 2, Rule 26 and Order 8, Rule 16 and 18 of the Supreme Court rules. The Supreme Court on February 13, 2020, barely 24 hours to the inauguration, sacked the governor-elect of Bayelsa State, David Leon, and his deputy, Bill Barakumar Degi, of the APC on the ground that Degi presented false information to INEC in aid of his qualification for the Bayelsa governorship poll held on November 16, 2019. The Supreme Court, upon review, maintained its judgment. On January 14th, the Apex Court sacked the governor of Imo State, Degi-Eremieoyo of the PDP, replaced him with Hope Uzodinma of the APC in an equally controversial circumstance, the outcome of which is now before the Apex Court also for review. Kayode Ajulo did not mince words when he concluded that the review applications are dark agenda by a section of the bar in cahoots with some politicians to cow the Supreme Court and to introduce public sentiment into issues which have been settled by the court. The Supreme Court, delivering a unanimous judgment on the application for review in the case of Bayelsa, held that the application by the APC and Leon lacks merit and that the court lacks jurisdiction to review its judgment, saying, "No force on earth can force the court to change its decision."